There was lots of talk after Brexit that IP litigation in the UK would see a downturn, but that hasn't happened. What we're seeing is the court is incredibly busy, a lot of patent cases, but also what's sometimes called soft IP. Don't much like the name, but everything else. So certainly trademark cases, design cases, and a lot of copyright cases also going through at the moment. You'll know here that we have 3 strands of the High Court that hear IP cases. So there's the Intellectual Property Enterprise Court for lower value cases between usually small to medium-sized enterprises. There's the Shorter Trial Scheme, which again for smaller matters, and then of course either the Chancery Division or the Patents Court to hear the really big cases. We feel that gives parties here a great deal of choice. And it's a choice whether to be quick and inexpensive or the all services, disclosure, cross-examination of witnesses, long hearing that you might want in particularly complex cases. There's been a lot of talk about AI and its impact, particularly on litigation from the court's perspective. And one of our very senior judges, Lord Justice Burse, has said that he himself has used AI for a judgment in very specific circumstances. So I think it's coming and it's happening. At the moment, there are a few challenges. One of them is parties who use AI to generate submissions when the AI hallucinates and you get case references that just don't exist. And obviously that's challenging for all concerned, particularly if it's done by registered practitioners. But in any event, whoever does it, it does cause difficulties. The other thing I've noticed, particularly in proceedings before the registry, where it's quite often a litigant in person on the other side, is that submissions have got much, much longer because they're not having to generate them themselves. It's the AI that's generating often pages and pages of sensible-looking, authoritatively stated material, but some of it's just not true. And so that slows things down and means that things do clog up a little bit in the registry. What's the future? I think everyone is watching this space to see how useful AI will be. It's certainly been useful for disclosure, what you might call discovery, for years and years and years. And much of that is now done by AI rather than by junior lawyers looking through folders and folders of documents, which is how we did it when I first started. And I think that's to everyone's benefit, frankly. But we'll have to wait and see what comes. I think the days of AI helping with decision-making are not actually that far away. And whilst I would always hope that a human judge will have some very significant input into the decision. If AI means that a decision is only taking a week or a couple of weeks rather than a couple of months, then that's got to be a good thing. It's always interesting to talk to judges from around the world, and particularly if you're litigating here or you're from a legal system based on the English legal system, so the common law world, which obviously includes the United States, Canada, Australia, New Zealand, India, large range of countries, then what the English judges have to say about procedure, about intellectual property, is fascinating. And I'd strongly encourage people to take that opportunity whilst they're here. I'm told that copyright law came about to help protect Queen Anne's favourite fabric patterns some hundreds of years ago. So in some ways, we can claim that some IP rights were birthed here. And I think that's an exciting thing to explore with today's judges who really are setting the pace for IP decisions in this jurisdiction.